Hello, everybody. This is Joe from PrepAgent. Hope you're having a great day. How's everybody doing today? Today is Wednesday. So I apologize for yesterday. Yesterday we had a little bit of issues, but today we are back on track. So that is always good. So yes, I used a PowerPoint presentation. Hope you guys enjoyed it. And now we're back to business as usual. So today we are talking about property transfer. When you guys talk about property transfer, you hear a four-letter word that starts with the letter D and ends with the letter D. Who knows what that is? Who knows what that is? What do you guys think? And the word is deed. What's a name for those words where if you flip it around, it spells the exact same way? It's a word for that, I feel like. Where's the super smarty people here? Where if you like flip it around, it's exactly the same. Can't think of any. Okay, so we got a deed. So what is a deed? What is a deed? That's right, Mike, like race car, exactly. It is not a synonym. What do you guys think? Okay, so a deed is evidence of a transfer. Nice job, Adrian. Palindromes. You do not need to know that for your exam. So that means that everybody's going to remember that palindromes that's what it is. I just said you don't need to know it. And once I say you don't need to know it, you're going to remember it forever. Isn't that the way the mind works, guys? Right? Okay, so a deed is a palindrome. Okay, so a deed is evidence of the transfer. Evidence of a transfer. Okay, it's evidence of a transfer. What represents ownership? What do you guys think? What represents ownership? Title represents ownership. Good. Title represents ownership. There's different types of deeds that we talk about. Who can name one of them? What is one type of deed that we like to talk about? A quitclaim deed is one. Good. A trust deed's another. Excellent. We got a general warranty deed. Good. Special warranty deed. Grant deed. Good. So you guys see this word deed comes up a lot. It's also reconveyance deeds. So do we know what any of those are? Who could start with one? So there's bargain and sale deed. So I see bargain and sale deed, warranty deed, trust deed, reconveyance deed, quitclaim deed. Who wants to start us off with one of them? Who wants to kick us off today? Pick one, anyone. Let's make it interesting. Which one should we talk about first? So we talk about property transfer. You're mostly talking about deeds. All right, so Mike wants to start us off with a quitclaim deed. Great place to start. Okay, so what is that quitclaim deed all about? Let me ask you this. Let's start this way. We want to change it up every week a little bit. When would you use a quitclaim deed? Let's start with real life scenarios. Who could give me a scenario where a quitclaim deed would be appropriate? Who could give me a scenario when a quitclaim deed is appropriate? Andrea says family members. Andrea or Andrea? I feel like it's Andrea. Okay, so a quitclaim, so a family members, when you sell your house to your sister, good. Divorce is a great example. So divorce, when you have two people who get divorced and you want the divorce to be clean, if one person gets money and the other person gets the property, they could just quitclaim their share to the other person. Okay, so you can just quitclaim your share to the other person. The spouse who's receiving the property doesn't mind that because they've lived there. They know the problems with the property. They know what kind of encumbrances has, all that kind of good stuff. So the immediate transfer of ownership is appropriate because that person's been living there themselves their whole time. If they bought it before marriage, Vicky, that's a completely different scenario. Then we're talking about a completely different entity because they bought it as separate property, and that's a whole other can of worms. Okay, so a quitclaim deed be appropriate for marriage. Jason writes a father property to son. Excellent. So these scenarios with a quitclaim deed, the person receiving the property is no stranger. Okay, is no stranger to the property. Usually they're very familiar with the property, or at least very, very familiar with the person. Right, guys? Everybody got it? Right, got it. If you got it, give me a got it and a thumbs up. So it seems like we all got this concept of the quitclaim deed. And the official way to say this, and you guys are going to want to write this down, a quitclaim deed has no expressed or implied warranties. No expressed or implied warranties. Maybe Adrian will write down what that means. No expressed or implied warranties. Do any of you guys know what that means? Because that's very legal jargon. What does that mean? No expressed or implied warranties. Who knows what that means? When they say a quitclaim deed is no express implied warranties. And I hope you guys realize when we do these webinars, part of my goal is to make sense of some of these legalese that you see. Because when you go home, you're going to just do a lot of questions, memorize things of that nature. My goal of these webinars is to take a step back and give you a little more context with this, give you a little more of a foundation. So when you do move forward with your studying, you'll be able to learn more as you have that kind of foundation and that general understanding. So all those details you start practicing and learning, they start to fall into place a little more. Has everybody got it? So you can't just rely on these webinars, but they can be an essential part of a complete study plan. All right, so Adrian wrote, express warranty is a seller's promise or guarantee that a buyer relies on when they purchase them. So basically it means that there's no things like encumbrances, a lot of debt owed, and with a quitclaim deed, they cannot say that. All right, they cannot say that. They cannot say that, all right, I guarantee there's no problems with the property regarding liens, encumbrances, like debts, lawsuits on the property, things of that nature. You take on the whole property. Is everybody got it? So it's kind of like an as-is, Mike, but it's not as-is in the sense of the physical nature of the property, which is what I talk about when you sell the property to your average seller. Okay, so the next thing is my question of, would you use a quitclaim deed if you're buying a house from me? So we haven't met each other. You seem nice. I seem nice. We're selling that property. Okay, I'm selling my property to the public. You seem nice. You want to buy it. We're not like close friends. We're just two nice people trying to complete a transaction. What do you guys think? In that scenario, would you use a quitclaim deed? No. In that scenario, depending on your state, and this varies state by state, you'd either use a grant deed or a special warranty deed. Okay, you would use a warranty deed or a grant deed depending on your state. All right, everybody got that? So some of you guys would use a grant deed, some of you guys use a warranty deed. For those of you who are confused, the two of them function the same way. They function the same way in that they do watch out for things like liens and encumbrances and things of that nature. A general warranty deed and a special warranty deed have a difference. What is it? What is the difference between a special warranty deed and a general warranty deed? Who knows? What is the difference in those two things? Okay, it's actually much simpler than you guys may realize. A general warranty deed goes throughout the life of the property. A special warranty deed is only regarding the previous owner. And a quitclaim deed is zero, nothing. So if you think about time frames, General is for the entire life of the property. Special is regarding only the previous owner. Okay, and we call it the quitclaim deed does it for nobody, nothing, nada. Has everybody got that? You guys could look it up if you want. Adrian, would you mind writing that down? If you can't, don't worry about it. General warranty deed goes for the total life of the property. Special warranty deed is just for the previous life of the owner. And quitclaim deed doesn't have any deeds. Okay, so we just went over a few deeds there. Grant deed, warranty deed, general warranty deed, quitclaim deed, etc. Do you guys know what is a trust deed? Before we do that, let me ask this. What's a reconveyance deed? A reconveyance deed. What's a reconveyance deed? I don't hear any music, Greg. I think the music's on your computer. I don't have any music on my end. What's a reconveyance deed? So a reconveyance deed is when you pay off your loan and the property goes back to you. Okay, this is when you pay off the loan, property goes back to you. You may be thinking, what do you mean goes back to you? Isn't it yours? Well, when you get a loan from the bank, what kind of title do you have? What do you guys think? When you get a loan from a bank, what kind of title do you have? When you get a loan from a bank, what kind of title do you have? You have equitable title. And then what does the lender have? What does the lender have? The lender has legal title. Whether using a trust deed or a mortgage is the same concept. So you as the borrower have equitable title and the lender would have legal title. What is equitable title? What is equitable title? Anybody? What is equitable title? So equitable title basically implies two things. Possibly more, but pertains to, but you guys need to know there's two things. One is possession. Okay, you have possession of the property. And two is the right to gain equity. I see some of you guys writing a cookie, and I know what you're getting at because very often I describe equity as your money you get after you sell the property that you could go buy a cookie with. So that increase in value above the original debt is yours if you have equitable title. Hence, equity, equitable title. Okay, does that make sense, guys? Everybody right? Makes sense. Makes sense. Okay, equity, equitable title. You get the equity. You also have possession. But there's one important thing you do not have. The person with legal title has something very important. What is that? What does the person with legal title have? What does the person with legal title have? They have the right to sell the property. So you may be able to enjoy the equity, and you may be able to live there and kick your feet up and watch TV, but you cannot sell it. Why do you not have the right to sell it? It's your property, right? You're living there. It's your picture on the wall. Why do you not have the right to sell it? Why not? Good. Dan McCarthy says you haven't paid for it. Basically, because, and here's, I want to phrase this in the technical sense. Nice job, GOTDO. Perfect. Because that's the bank's collateral. That's their security for the debt. Everybody got that? That's their collateral. What does that mean? That means if you don't pay the money that you owe them, right, they need to be able to sell that property to satisfy the debt. Everybody got that? So the property is the collateral. Okay? And going back to that reconveyance deed, so if you pay off that debt to them and you don't owe any money to the bank, well, then they will reconvey the property to you and give them legal title. Because the only reason they have that legal title is to have collateral to satisfy the debt if need be. So if it's paid off, they don't need it, and they reconvey it back to you using that reconveyance deed. And that reconveyance deed shows that you paid off your debt. Everybody got it? This is not just for your exam. It is important for your exam, but this is also something you should understand just in your general practice of real estate to understand basically how things work. Okay, everybody got that? And if you don't pay off your debt, that legal title gives them the right to do something called foreclosure. Foreclosure. Da-da-da-dum. Foreclosure. Okay, boo, foreclosure. Boo, foreclosure. All right, guys? So we discussed equitable title, legal title, touched upon some deeds there. All right? And there we go. Okay, let's do a question on the board here. Ralph sold his house to Oscar, who did not record the deed, but took residency there. Ralph then sold the same property to Larry, who reviewed the county recorder's records, but did not examine the property. Ralph gave Larry a deed, which Larry recorded. Which of the following would not be true concerning title to the property? A, Oscar maintains title. B, Larry has recourse against Oscar for failure to record. C, Larry and Oscar are co-owners of the property. Or D, Larry now owns the property because he recorded his deed first. What do you guys think? And the answer is Oscar maintains title. Good. Possession and recording function the same way. They both give constructive notice. And therefore, the person who did that action first would get title. And Oscar took possession before the recording happened, so he gets title. This is one of those things I want you to know for the exam. Exactly how this works in real life, I don't know. This is not something that comes up very often. So just limit this to something you need to know for your exam. By the way, in case you guys forgot, for those of you guys like printed material, don't forget that in the top right corner here, you can always print out these practice exams. It's another feature we provide. We try and provide you guys everything you can so you could excel. And we try and make it so everybody could tailor the studying in accordance to what works best for them. So don't forget, we have this nice little print option in the top right. You can always print out the exams. What is a will written and executed entirely in handwritten of the testator? A, a written will. B, intestate will. C, holographic will. Or D, invalid will. And the answer is C, holographic will. Tomorrow webinar will be at 4 o'clock West Coast time, which will be 7 o'clock East Coast time. And you guys do the math if you're somewhere between New York and LA. And Adrian will be leading that webinar tomorrow. So I hope you guys are excited. Yay, Adrian. Okay, a riparian owner owns land which borders on A, any body of water, B, the ocean, C, a stream, or D, a lake. Paula wrote riparian river, and as we know, Paula, more of a memory technique. So the river alludes to a moving body of water, right, guys? So river, okay, means moving body of water. So you're at stream. Vicky, if the screen's not clear, make sure you change the settings to 720 HD. The little gearbox on the bottom right of the window. Click on that and change it to 720 HD, and your screen will be fine. It'll be clear. Property tax are described as ad valorem. Ad valorem most nearly means A, market value, B, according to value, C, replacement value, D, reproduction value. Oop, we got some weird symbols going on in this question. I will write that to our crew. It's weird characters is the right word. I can't spell weird. Okay, and the answer is B, according to value. B, according to value. Okay. What happened again? Which of the following would be an example of a boot for income tax purposes? A, debt relief for mortgage in the exchange. B, a decrease in the basis. C, a decrease in the real estate property taxes. Or D, an increase in deductible depreciation. Adrian, you see those two that I just sent? We have to fix those for the viewing pleasure of our audience. Okay, the answer is A, debt relief for mortgage basis. Okay, so what we're talking about here is something called a 1031 tax deferred exchange. What is a 1031 tax deferred exchange all about? Who knows? I'm not wearing bracelet. Is it hitting my microphone hitting against my shirt? You hearing a little noise like that? Is it better now? Okay. So a 1031 tax deferred exchange is when you sell your property, you do not touch the money, you take the money and you reinvest it into a new property. The key point is you don't touch the money because that money will get taxed if you touch it. So you take the money from the old property and you reinvest it in a new one. Has everybody got that? Now, some of you guys are writing down 45, 180. That is, you have 45 days to identify the new property and 180 days to close the deal on it. Very important to note there. 45 days to identify, 180 days to close. When you guys get into real estate, I highly recommend you research this. There are licensees who spend their whole career just focusing on this. Because although we are talking about on a very surface level, so you guys could pass the exam and get a basic understanding of it, this is a rabbit hole that has a lot of ins and outs and details that you could go into if you guys want to focus on this for your career. And as you guys launch into your career, keep in mind there's a lot of little niches within this grand thing called real estate that you can explore. Many of those niches, you need to have a real estate license, such as working with 1031 tax deferred exchanges. Okay, so it's one more thing for you guys to look for. So if you guys are looking for ways to differentiate yourself as you enter real estate, this is one idea of many ideas that you guys could explore. Okay. If you sell a property and buy it, you don't have to. Yes. There is a way you can watch YouTube without the ad showing up, Mike. I forgot how it is. Arthur showed me a while ago. Just Google that. I forgot how to do it, though. But there is a way. Vicky, I'm not sure if it's used for flippers. I guess you could, but I don't think that's what it's intended for. Okay, when a real estate broker speaks of tax shelter, she is referring to A, real property taxes, B, income taxes, C, net income, or D, principal payments. That's right, Mike. There is a way to watch YouTube without the ads, although I'm not an expert in that, and we'll do that on a different webinar, a different day. I'm pretty confident if you Google it for like 5-10 minutes, you'll find it. Okay, tax shelters for income tax. Under federal income tax law, the basis of real property is A, assessed value prior to sale, B, fair market value, D, purchase price minus any existing assumed loans, or D, cost. Vicky, worry about flipping homes till after you pass your exam. Let's get past this exam. Okay, the cost basis. Which of the following deeds contains no express or implied warranties? A, warranty deed, B, bargain and sale deed, C, grant deed, or D, quitclaim deed? We went over this when we started the webinar. The answer is D, quitclaim deed. An attachment is A, a joint fixture, B, a lien, C, a judgment, or D, an assessment. Okay, B, it's a lien. Means you owe money. You owe money, 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 money. We'll talk about liens another day. The marginal tax rate is defined as A, the 29% tax rate, B, 22% of gross income, C, the tax rate which is applied to the next dollar earned, or D, the tax rate which is applied to the last dollar earned. C, the tax rate applied to the next. Which of the following is not subject to taxation? A, patents and trademarks, B, a boat, C, a house, D, an income. A, patents and trademarks. Good. Title to personal property is transferred by A, a bill of sale, B, security, C, notice of bulk transfer, or D, chattel mortgage. The answer is A, bill of sale. Good job, everybody. What is the meaning of a quiet title action? A, purchase of property through a dummy transaction. B, an action to quiet a noisy title. C, court action to remove a cloud on a title. Or D, foreclosure action. C, court action to remove a cloud on title. A bill of sale is used to transfer for the ownership of what? A, fixture, B, appearances, C, personal property, or D, real property. And the answer is C, personal property. To alienate title to property, 1A, conveys title, B, records a homestead, C, encumbers the title, or D, clouds the title. And the answer is A, conveys title. Good. All right, guys, that's it for today. And I want to tell you guys how much I appreciate you guys coming to these webinars and participating. I'm fully aware how stressful studying for the exam could be. I started a new career. It was not easy for me to prepare for the real estate exam. I was extremely nervous and scared. I had to study hard. I had to learn a lot. And I was very nervous about it. I was not comfortable with it. So I fully appreciate how stressful this could be. I do not take that lightly. Therefore, we're all honored and very grateful and appreciate that you guys put your trust in us to help you guys pass the exam. And I want you guys all to know this is not something we take lightly. And we're always trying to modify the way we do things the website, from being able to print things out, or little buttons, or anything we could do to make this information a little bit more easier to digest, because it's not fun. Okay, so I appreciate it, guys. And tomorrow, Adrian will be here, and he will do a great job as always. And I will see you guys soon. Thanks, everybody. Have a good day. Bye.